The topic is legality of sting operation. And sting operation is something that we know very well. It is very interesting. It is very sensational also. Uh, 20 years back, 10 years back, when we never had this social media type thing, when news channels, some sting operation uh, used to come, it was talk of the town. And so we are aware of many such sting operations of those days. Some of them has led to High Court and Supreme Court also, and that we will discuss. So sting operation is indeed something that we know, but for clarity, this whole discussion has 4 pointers. What is the meaning, origin and scope? What is the legal regime in USA, Canada, UK and India? They are all common law countries. As Professor Atul sir has rightly mentioned, that the legal regime is fluid, it is unsettled, not only in India but all over the world indeed. Probably it is high time something will have to be done because of this upsurge of YouTube videos and Twitter and video mode with everyone's mobile phone, and everyone is willing to capture something. Then third is the judicial decisions that we try to discuss, and then what is the way ahead. We will try to find this 5-6 ways that can be maybe some pointers for us. Now, as we know what sting operation is, but let us begin with an informal meaning of sting. According to dictionary, sting means a carefully planned operation. Sting we all know, डंक कहते हैं हम sting को हिंदी में. But dictionary meaning for our purpose is that it is an operation which is planned, number one, and which is very careful also. And this involves deception. So the involvement of deception that the other party does not know is very significant. So it is a planned operation, but it is not known to other party. It is generally said one of the purpose of such type of sting operation is you lie to nail a bigger lie. So you have to choose between two necessary evils. So you choose the lesser evil. There are 2-3 purposes for this. For the purpose of government, it helps in crime detection, crime prevention. It is useful in administrative matters sometime. For the purpose of spying, to know secrets of enemies, such type of operations are used. I may refer to one of the series on Hotstar, Homeland. You can find a number of maybe spying operations, sting operations type thing. It involves conspiracy. So for the purpose of government, crime detection and sometime for administrative matters, this type of sting operation is done. Law Commission of India has recognized it. In its, at least in 2 reports, it talks about not directly on sting operation, but on entrapment. And they recognize that even in the civilized world, there are certain offenses, if not all, certain offenses that cannot be detected easily without taking help from agent and decoy or trap witnesses. Why? Because crime is no more in its classical mode. We are aware of white collar crimes. We are aware that people are involved. International agencies are involved. There are people who train for this purpose. Take example of national security crimes. terrorist crimes, where a whole country is involved for this purpose. So in those cases where there is a regime of protection, either at the national level or at the domestic level sometime or at the international level, or they are so sophisticated, so much trained, so much well prepared, legally, socially, sometimes politically, that it is not possible to find evidences against these people and these offenses. Not always, but sometimes. Similarly, take example of corruption. Take example of drug crimes. High stakes are involved. So, and because the threshold is beyond reasonable doubt, so even if there is an iota of doubt, the judiciary has no option but to leave them. Because high stakes are involved in many such cases, they are able to get lawyers who charge in astronomical units. So in certain cases, there is a possibility that there is battery of lawyers who charge maybe 10 lakh rupees, 20 lakh rupees per hearing, and on the other hand, state is being represented by one senior public prosecutor. So therefore, Law Commission of India and all over the world, it is rightly recognized that in some cases, there is TINA factor that works, T-I-N-A. TINA factor comes, it is usually used during elections. There is no alternative, T-I-N-A. So therefore the trap witnesses, decoys are part of criminal justice system. Then the second entity is non-government entities, non-state actors, like individual, me and you, like media companies, media houses indeed. So media houses, they have their fourth pillar of democracy. It is their duty to expose wrongdoings that is going on, especially in the area of corruption, in the area of nepotism, in the area of arbitrariness, in the area of derailment of criminal justice system, and we will try to see at least in one case of R.K. Anand. Then companies are also sometimes engaged in these type of stings. There are instances where companies have been are using sting operations, sometime morally, sometime immorally, to find the secrets of other companies. Then civil society and group also can use sting operation. So there are examples that in some societies, in order to show the lethargy of maintenance company of a society, residential society, some sting operation was done. Now it has become easier, as it is in the beginning it was highlighted that everyone has, most of us, not everyone, most of us have a cell phone, and many of us have around internet connection, so we can have, we have a camera and we have video, and then it can be uploaded. So far as these non-government actors are concerned, they have, some of them have fundamental right under Article 19 in India. First Amendment of the USA Constitution also provides them right, freedom of speech and expression. Sting operation is one of the measure of freedom of speech and expression. We express ourselves, and we have right to express ourselves. Similarly, press, right to press. While press is recognized in the USA in the First Amendment, in India it is not expressly recognized. But then the whole business of press is to expose wrong things of powerful people, be it in the politics, be it in religion, be it in ideology, be it in any other sector, media, be it in business. And they do it. How will they do? They do through sting operations. It is a part of fundamental right. Companies, Article 19 does not provide company, because companies are not citizen, so they don't have fundamental rights, but their stakeholders can certainly enjoy this right. And the groups also, because groups have fundamental rights. We will see that it is not only a matter of Article 19(1)(a), but 19(1)(g) also. So someone can do it as a matter of business. But okay, but let us begin with this. This sting. The sting is 1973. There was a movie that came, and it made this sting operation very popular. It is said that this movie made the sting operation very popular, though there were cases not on sting directly, but on entrapment. But the sting should not contain artificial attraction. One of the example can be in 70s, in 80s, in the 90s. Before I come to this, yes, there was an example that a media house received complaint in USA that it is very, very difficult to run any business with honesty. So opening of bar was one such example. So what the media houses, 4 persons of the media houses have done, they opened 4 bars at certain places. And we all know opening bar needs some license. So they tried to get license, but getting license was not easy. So the 4 months they continued with that bar. In those 4 months, people from official side, someone who is responsible for police, someone who is responsible for other enforcement agencies, someone who is responsible for licensing, someone who is responsible for other things, they used to come meet these 4 journalists, and whenever there used to be a talk on license, they used to say there is no need, we are here to protect you, just give us our share. So for 4 months they have done nothing. Indeed, they have not attracted through money any person. They have not given money deliberately to anyone. People themselves, official people themselves came to them. They told them that you run this real bar, no problem. Just give us our monthly share. This story they continued maybe for 4 months, and after that they have exposed it in the newspaper, and that exposition because of that there were various legal proceedings also that took place. So the point is, in those type of operation, it was again a sting operation, because sting operation does not say that it should be with the help of some recording. Recording is something new. Sting operation means a careful operation where you do something other party does not know. So that was a type of sting operation. But in that sting operation, they have not asked anyone to participate in something which is unlawful. In India, we are aware of many stories. The Tahalka leads this. It has done various great stories. So political donations, they operate on dangerous quid pro quo. They have indicated. cash for question scam, that I will give you money, you ask question in parliament. Then in Gujarat riots also they had shown how in some cases the prosecution has not done the work properly. BMW sting is probably the most significant. We are aware that in BMW case, uh, the witnesses, the accused, the advocates, even the prosecution, they tried to derail the whole system. Talca has done this story and then it was telecasted in NDTV and other places, and then it led to Supreme Court cases and conviction also. GTV also. So there are a lot of sting operations which we are aware, and during during election time they do come in picture. I will again go back to USA. One sting of 1993, and you can read this, that there was indeed around 600 letters were written to certain people. These people were indeed staying in USA without any authorization for a longer period. So 600 people letters were written. A letter was written, it seemed like some government authority has written the letter. You may be eligible for employment authorization. So the letter suggested that you will get some employment and then some amnesty program also. For example, you are here and your stay visa is gone, or there is other problem, then one time amnesty we are going to give. What you are required to do, you report in room number B247 at this time to this time on this date, that is July 20, 1993. Please bring this letter and some identification with you. And they also said that if you do not report, then you are ineligible to receive your employment authorization under this scheme. You can see that they have mentioned Immigration and Nationality Act of 1993. And then there is a signature of some authority also, district director of something. When this letter reached to certain people, some of them turned up. When they turned up, it was found that the enforcement officials were waiting for them and they detained them and they started proceeding for deportation. So the matter went to the court also, and the first question that was asked was that why, when you were aware of the address of 600 people, why did not the authorities approach them directly instead of sending a false type of invitation, a fake invitation from government side? So should the government and the authorities work on fake names, fake addresses, fake maybe fake invitation? So the answer given by the authority that we don't have enough resources, and therefore we asked all of them to come and join. So they had some success. This incident was criticized severely and therefore was not welcome, but this is also one example of a type of sting operation in USA which became very famous or infamous. Now you can see that in the invitation they had discussed that Immigration and Naturalization Act, there was no law of 1993 indeed. So the name of the act was wrong. The address was the person who has signed, he was also fake. Now, the regime of USA, the authorized word on this sting operation, there are many cases, but one significant case is Keith Jacobson versus United States, 1992. It has been quoted by India also, it is quoted by Law Commission also, it has been quoted by other uh, authorities. In their zeal to enforce law, law protectors must not originate a criminal design, implant in an innocent person's mind a disposition to commit a criminal act, and then induce commission of the crime so that the government may prosecute. We find there are three elements. One, that it should not originate criminal design. We will discuss one by one. And then an innocent person is an element, and that disposition is probably third element, and fourth is induce the person. These four elements we will discuss one by one. And they say that in the entrapment, if it is done, it is not permissible under law. The prosecution must meet an answer for establishing and answering beyond reasonable doubt that the defendant was predisposed to commit the criminal act prior to first being approached by the government agents. So there is a difference between a person who is all set to commit the crime and someone who gets the opportunity, then he commits crime. There is a difference, and this difference the authorities need to keep in mind. This has become, this ratio of Keith Jacobson is also law for our country, because at least in one case, Uma Khurana case in India, the High Court has accepted this ratio. So for the purpose of India, I think Uma Khurana is one case which has referred this case, and this is a ratio for our country. Now, so far as sting operations are concerned, there are two types of cases. There were legitimate entrapment, legitimate type of thing, and second is illegitimate. So sting operations, especially by the government, can be illegitimate also. And what is the philosophy behind it? You can see 3-4 points have been made. The purpose of sting operation is to catch the criminal, not to create criminal. We will, with the help of one or two illustrations, we will try to find when can it be said that we are creating the criminal, and when can it be said that we are catching the criminal. Thank you, John. Please keep your question. We will discuss. Second is that legitimate entrapment or sting operation, which can be lawful, it can be lawful only if you are dealing with somebody who is a present criminal, not somebody who can commit crime. Can commit crime does not mean that a person who are going to commit cannot be prevented. This only means you cannot make an environment and push the person in such a fashion that he turns into a criminal. So with two illustrations, we will try to find how. So what is the difference between present criminal and future criminal? Then specific disposition, not the general disposition. I have in mind so many things. If given an opportunity, I will do something wrong. That is a type of general disposition. We are all human beings. Supreme Court in India way back in 1950s have referred that we all are human beings with our strengths and weaknesses. So attraction is natural. I will be attracted towards money. I may be attracted towards maybe other things. It is natural. But then we struggle. We struggle and we try to control those attractions. And we all do it. So the general disposition, if it is type of general disposition through sting operation, then it is not permissible neither in India nor outside. It should be a specific disposition. So the enforcement officials should be very careful that is the disposition that the person wants to commit something is specific in nature or general in nature. This is something like maybe uh, finding a 500 rupee notes at some place and find a cell phone. I may be happy to take that 500 rupees if nobody knows, but may not be happy to take cell phone because I'm aware that cell phone can be tracked. But if there is a CCTV, probably I will not take it. So it is type of general disposition. A specific disposition is a different type of thing. So, but we will try to discuss that one also. This specific disposition means not ordinary temptations. Ordinary temptations are there in me and everyone. We are tempted towards attraction. That is okay. But if I am trapped with the stick operation, that will be illegitimate. So the purpose of sting operation is to prevent crime, help criminal justice system to prevent it, to mitigate it, not to manufacture or promote crime. So this we should keep in mind. And if it is not so, if it is with the nature is something that we are creating criminal, we are pushing the person to the extent, persuading to such extent continuously that his temptation becomes a specific temptation, from general to specific temptations because of my hard effort. Then in Sherman versus USA, the Supreme Court of USA says it is a coerced type of confession. It is as good as unlawful search. So we should be very careful, and the illustrations will make it very clear. That will come in next slide. But of course US law is there, but US law is not equally applicable because of various reasons. For example, fruit of the poison tree doctrine is applicable in USA but not in India. So is sting operation lawful? The answer is yes, for a limited, in a limited sense it is lawful. Is it a legal method of law enforcement? The answer is yes, but again to the limited extent. And what is that limited extent? That we have already discussed, that it should be lawful. It should be legitimate. So for drug trafficking, for political and judicial corruption, prostitution, I've already dealt with that. Many offences, or the nature of many offences are that it is very difficult to find evidences. But this is equally used for traffic violations also. In the case of Sherman versus United States, again, which was discussed in last slide, the line which was highlighted for as a guideline was the trap for unwary innocent and trap for unwary criminal are two different things, and we should keep in mind. So to further dilate is, there are two situations. If the government agents are merely affording opportunities and some facilities, then this will be a legitimate type of thing, a prosecution will win. But the government agents like police, like maybe other enforcement agencies, they are more than creative, very creative, and pushing the person, then in those cases that such type of sting will not lead to conviction. I think the illustrations will make it clear. I will come to those illustrations. So what are the 4 points that we should keep in mind when there is a sting operation? Who initiates criminal design? What is the origin? So if accused is there who has been caught red-handed, what was the origin of criminal design? Did the officials themselves go and ask them, and then the design was created. Then the first is that the police is indeed initiating the criminal design, and that will make the case weaker. So generally the government agents may not originate a criminal design. Generally, exceptional cases like terrorism cases, one can do. Uh, so, so if we want to make this very strong, we should not be a part of beginning of criminal design. Second is, once the criminal design is clear that Mr. So and so wants to do something, he has this in mind to do something, and then the enforcement officers have started interacting with him. Second is, who implants the disposition to commit a criminal act? Is it the self disposition? खुद ही उसके अंदर ये भाव है कि हाँ हमें करना है अपराध, or is it implanted seriously, persuaded to many days, many calls were made, हाँ आपको ये करना है, you have to do it. For example, the last case that we discussed, Jacobson, what happened in this case, that during 1980s in USA, all type of pawns were permissible. So, but with the passage of time, the child porn was made prohibited and punishable. The authorities wanted to know who are the people who are interested in child porns, obscene material that deals with children. So they found that Jacobson sometimes go to some bookshops and purchases some books which deals with adult content. So they picked his name, and they themselves assumed that maybe he is a pedophile. Maybe this person can be one of those who is interested in child porns or child in compromising position. So they started interacting with him. They sent them fake letters from NGO that, see, it is a part of free speech, and therefore the law which has prohibited child porns or child pornographic, it is not constitutional. Free speech, under free speech, nobody can teach us morality. So we are an organization who are dealing with this. Please support us. It is our right to know. So it cannot be prohibited, cannot be criminalized. He did not take care of those letters. Indeed, he was interested in some photographs, but he was interested in the photographs of adult people. Then again, after 2-3 months, so for around 5-6 months, people pursued him. People means the persons who are in the administration. They pursued them. They tried to exploit political right. They tried to exploit his personal disposition in many other ways. They also said that we sell these type of child porns which is not available easily. So we deal with that. There is an organization. Let us do it. Let us enjoy. And then somehow he was convinced that, okay, I can do it. And when he started doing it, he was caught. The question was that who implants the disposition to commit a criminal act? Watching an adult content is not, it was not, it is still not an offense. That is not offense in our country also if you do it in private domain. But watching or going through that child porn became unlawful. So who implanted that disposition? And ultimately his conviction was set aside. And the Supreme Court said that no, you cannot, if the person is self-disposed, that is all right. But you cannot implant in this way. Third point is that person an innocent one? This is crucial. This gives some help to prosecution machinery. I will come to that in another slide. And fourthly, who induces the commission of the crime so that the government may prosecute? So there are 4 pointers which we should be very careful when a sting operation takes place and if you want to get the protection of law and judiciary. These 2 key points were taken from Matthews 1988, which was prior to Jacobson. So I'm just skipping this part of this part. Now, just presenting before you 2 scenarios. Scenario 1, that there is Mr. X who has 2 prior convictions under drug law. One for possession of heroin with intent to sell and other was for possession of cocaine. And X was recently acquitted for possession of controlled substance. Y is a well-known crack, and I have seen the dictionary, and crack means I was not knowing the meaning of this crack here. I saw it is street cocaine. So Y, a well-known crack wholesaler, offers to sell crack to X. X agrees to buy a significant amount. And he also says that he will make a lot of money and he will sell it on retail. So a place was decided and time was decided, and X gives cash to Y, and indeed and then immediately the government agents appear and they arrest. So it was a type of sting operation. Is it a valid type of sting operation, or is it an invalid type of sting operation? Now, if we see the scenario, who is the person? Person is not innocent. You will remember the 4 pointers that were made. Yes. Third point, is that person an innocent one? Of course, in the eye of law, he is innocent because there was no case. But for the purpose of police, he is always a suspect because he had 2 prior convictions. Indeed, law also recognizes it in many cases. So, second is that Mr. Y has approached and told him that I will sell crack to you. Just. So an offer was made to him. And X agrees to buy a significant amount. This agreement shows that he had this self-disposition. He wanted to do it. It was not created by Mr. Y. Y has offered. Of course, he has. He was one of the beginner. Let me come to the next illustration. In the next illustration, X is someone who has no conviction, no records, but he resides in a locality which is full of those type of drug dealers, drug peddlers. X knows various drug dealers personally. Y approaches him that he wants to sell those drugs. Y asks S to sell cracks. Sell cracks. So he refuses. The person refuses. And then the person who was from official side, he pursues, he makes calls. And during calls, he convinces over days that he needs such type of drugs desperately. And then he also brings some maybe emotional type of blackmailing by telling that his sister needs it because she is in pain. And he contacted the person for around 1 week. And then he was convinced, and then he buys from a dealer and sells to Y. And then government agents immediately appear and arrest. This scenario is different from the previous one. Number one, the person himself has no conviction, no records like that. So the scenario for a prosecution, for police officers, for investigating machinery is little difficult. Second is that when he was offered, he did not accept it immediately. So to prove self-disposition is a very difficult task. And then continuous calls over days and for 1 week, continuously contacting him and then making him ready for this type of transaction. This is a very, very weak type of evidence, and this type of evidences is not leading to conviction. These are type of illegitimate trap or illegitimate entrapment or illegitimate maybe sting operations. So the point is that if the person is innocent, means the person, there are chances that maybe he can commit crime. But then once he has refuses, you are trying to create an intention in that, and if you are trying to create intention and pursuing that, this is not going to help, at least in law. So the predisposition with the defendant was unwary honesty and unwary criminal who readily availed the opportunity to perpetuate the crime. This Matthew's cases, we have discussed this thing. I am skipping this point. So we come to two types of liability to conclude this part of discussion: subjective liability and objective liability. And it is significant in the sense that this is applicable almost in Indian jurisdiction and US jurisdiction. So, was he predisposed to commit crime? पहले से ही तैयार था, हमें थोड़ा ही प्रयास करना पड़ा. So he cannot take the defense of entrapment and prosecution will win. So that is subjective liability. So the prosecution, first the investigating officer and then the prosecution should be able to establish beyond reasonable doubt that indeed he was predisposed. We had only provided him opportunity. We were just a wheel, just a type of small catalyst to commit the crime. This is subjective liability. Second is objective liability. Objective liability is the government involved improperly? Means the persuasion is more than which is required. This intention is being manufactured. In those cases, entrapment defense is applicable. In other words, the prosecution, the investigation will fail, and the prosecution will also fail. So there are two types of liability, and the subjective liability holds the field. Now regarding, sometimes there are the questions regarding evidences of these type of evidences that are produced through these type of sting operations. Are they valid if the other party is not knowing what will happen? So I will begin with the philosophical means the reasoning and the philosophy which was given by many authors. I am quoting Herbert Packer for this, from the Limits of Criminal Sanction, which was written in 60s. And he says that in the event there is no reason why evidence should not be used in the criminal process without regard to the manner in which it has been obtained. Here, unlike the problem of the confession, there is no question of trustworthiness or reliability. Physical evidence is physical evidence, regardless of how it is obtained. If one suspected of illegally possessing heroin is found to have heroin on the kitchen shelf, this supply of narcotics is reliable evidence of his guilt, whether the search that turned it up found by some judges to be legal or illegal. So at least in our case, it is clear that even if the search was illegal, in our case, the evidence can be used. Now let me discuss the legal regime in Canada. The Canada legal regime is not very different. They have also given maybe 7-8 points. So they said that it depends on the type of crime which was investigated. Then again, this whether an average person with both strength and weaknesses in the position to be induced into the commission of crime. So I think I don't want to repeat, because most of the things are similar in nature. Only the descriptions are changed. For example, whether the police has exploited the particular behavior, human characteristics, लालच में हम पढ़ सकते हैं. So I'm not repeating that one. Now position in United Kingdom. In the United Kingdom, the position is not very clear the way it is in USA and India. There are 2-3 cases, and in some cases the courts are of the opinion that yes, this type of evidences will be applicable, will be permissible, but then there are other cases which don't favor this type of sting operations and do not allow them to be used as an evidence. For example, I may quote, a prosecution founded on entrapment would be an abuse of court's process. Entrapment is not a matter going only to the blameworthiness or culpability of the defendant, and hence to sentence as distinct from conviction. Entrapment goes to the propriety of there being a prosecution at all for the relevant offence, having regard to the state's involvement in the circumstance in which it was committed. So there are 2 different cases, but I don't think that USA can be a good example. Probably the judges in UK cannot be a good example. I think USA is the correct example for us. We have also followed that. UK means they are additionally cautious, probably because of the reason that there is no fundamental right in a written constitution. So they want additional protection. Now, I discussed with you that this is a matter of freedom of speech and expression. In USA, there is no express restriction. So while sting operation can be authorized, can get its legitimacy from Article 19 in our country, and in USA from First Amendment of the Constitution in 1791, we should be careful that so far as restrictions are concerned, in USA there is no express restriction. In India there are 8 restrictions. So maybe individual doing sting operation may get greater protection in USA but cannot get protection in India because of 8 restrictions. Now, what is the legal framework in India? I have discussed some of them, but in a far more organized fashion I shall try to do now. See, we all know to begin with that rule of law is a part of basic structure theory. What is rule of law? Rule of law means it is the law that rules. And when we say rule of law, that does not mean only written rules, black and white rules, But the values which are connected with law, they all form rule of law. So if there is some corruption, if unhealthy practices are going on in the field of medical sciences, maybe education, maybe in other areas, if some crime is being committed and it is unchecked, some crime is committed and it is protected by the government machineries. So it is the duty of every citizen to expose that, because they are against rule of law. So I begin with that indeed sting operations in most of the cases, because they show the weaknesses of law, they indeed help in criminal justice system. Therefore they are a part of rule of law and therefore they should be protected. I had already discussed under Article 19(1)(a) and 19(1)(g), it gets protection, it gets legitimacy, sting operations. Under Article 21 also, we know right to life and personal liberty. So there also one can get protection. Someone who is doing sting operation. So right to livelihood is a part of fundamental rights. Someone can say that it is a part of fundamental right. Corruption free society is a part of maybe right to life. Some of the obiter remarks of Supreme Court are there. So this is here the sting operations get protection, and therefore any law which is made to regulate sting operations, they should be taken care of under Article 19(1)(a), 19(1)(g), 21. There are ethical questions which are involved because there are deceptions. We do not inform the other party. There are enticement, and the end is justifying means. We all know what Mahatma Gandhi said, that the end and means both should be pious, but then there are certain limitations. In these cases, it is the end that justifies means. So legal question regarding this sting operations may be covered under Constitution. I have already discussed Constitution. Then under civil law, there can be case under tort if there is a violation of like trespass. If someone commits trespass, so their violation may be dealt under tort. So in sting operation, many cases trespass is done. Then if it goes against reputation, then again law of tort comes in picture. Then Indian Penal Code also, Evidence Act, we will try to discuss some provisions of CRPC also. Then there are 2-3 questions and they are not decided indeed. What is the evidentiary value of undercover? We will discuss 1-2 case on this, especially, and his non-accomplice. Is his evidence different from the undercover? And the answer is yes. But then if the confession made to the police officer who is not in uniform, what will happen to those confession? So suppose in a sting operation, 2-3 police officers, they go to meet some drug dealer, to meet some trafficker, human traffickers, to meet someone who is engaged in corruption or money laundering. And in a sting operation, someone makes some claim and there are confessional statement. Are these confessional statements hit by Section 25 of the Indian Evidence Act? So I will also take thoughts from the participants on this particular question. Let me reframe this question for all of you. That suppose there are 2 police officers and they have gone, so they are committing some sting operation, and during this sting operation, some video recording which is maybe concealed, someone makes some confession regarding money laundering, regarding trafficking, regarding drug dealing, regarding some crime committed, regarding forgery. Whether this type of confession will be hit by Section 25 of Indian Evidence Act or not. So kindly keep this question in mind and we shall try to discuss it. Now I have discussed with you, this is just refreshing our memories, that this protection is available, freedom of speech and expression is available to all citizens, they have right, and therefore sting operation is a matter of right. Indeed, the courts have also accepted it in India. But there are limitations and there are 8 restrictions, and here the difference between India and USA comes in. So sovereignty and integrity of India, security of state, friendly relations with foreign states, and public order. But mostly the sting operation can be restricted because of decency or morality. This is one. Contempt of court. Number 2, defamation, which is extremely significant, incitement of offense, and sometimes maybe public order also. So these are restrictions for sting operations. So you cannot commit sting operation in such a fashion that it violates decency and morality. If it does so, then the sting operation is not permitted, has no value. So is the case of defamation. If it is defamatory in nature, the action can be taken. It should not incite some offense. Then 191G, that talks about profession, occupation, trade and business. So someone can have a part of this as a profession. They can earn money from that. So, and it is permissible under fundamental right, Constitution of India. But then in the interest of general public, there can be some restrictions. Article 21 I have already dealt with, that right to life, livelihood is there and one can claim it. But then, as rightly referred by other panelists, right to privacy has become a very significant question, especially after 2017, when right to privacy has been declared as a fundamental right by a 9 judges bench in Puttaswamy case. So if a sting operation is done without let me know, does it violate right to privacy? The question is not settled, and I think more competent people like Professor Atul sir are there to address. But in one line, if I would say that right to privacy judgment itself recognizes detection of crime or investigation of crime as one of the exception. So there is no right to privacy if it is a case of detection of crime, of course under some regulatory mechanism. So therefore, if the government officers, public officers, enforcement officers are doing sting operation with proper authority, following regulations, following rules, following precedents, then probably right to privacy does not come in picture, because it is already an exception in the Puttaswamy judgment. Then the case which is very significant for our purpose in the light of sting operation is Subramaniam Swamy versus Union of India. In this case, section 499 of IPC, which deals with defamation, the constitutional validity of this case was challenged. And it was argued that I have freedom of speech and expression, and it goes to the extent of violating the reputation of any person, and only civil remedies are available, should be available, criminal remedy should not be available. And 499 should be declared unconstitutional. If reputation is violated, the civil law remedy will come in picture. But the Supreme Court did not agree. And the Supreme Court held that right to reputation and right to freedom of speech and expression both are fundamental rights. Right to speech is a fundamental right under Article 19, and right to reputation is a fundamental right, undeclared, unnotified, not notified, unexpressed fundamental right under Article 21, and there is no conflict between them. And if in case there is a conflict, a harmonious construction has to be made. But even then, always take note, you cannot claim right to fundamental right to freedom of speech and expression at the cost of right to reputation. In other words, in other words, right to reputation is more significant than right to freedom of speech and expression. Both are fundamental rights. So a sting operation takes place, and sting operation goes to the reputation of a person, it is defamatory, then number one, the sting operation can be prohibited to be displayed on television. Take example of one sting operation which was done by the staff of a very well known lawyer who was found in compromised position in his chamber. So it was a sting operation, it was being telecasted, but then it came to the High Court, and the Delhi High Court said that no public purpose is being served. What the lawyer or any other person is doing is a private matter in his chamber. It is consensual. So you cannot record it, and if you record it, then you cannot maybe place it in public domain. It is against right to, maybe it is no fundamental right is available. So I think in the case of sting operations, especially these days when we have mobile phones, cell phones and video cameras in our pocket, it is right to reputation and right to privacy which is going to hold the field for next maybe 20-30 years. Then in this context, right to reputation, we can highlight the case of Uma Khurana, a very unfortunate case. That shows that how in order to express the fundamental right to press, sometime the professional compulsion means takes away all moral values from us. What happened in Uma Khurana case, and we all are probably aware of, that a news channel has telecasted that there is some teacher in a Delhi government school who pushes girl in the prostitution business. This is certainly very serious issue. There is a relationship of trust between teacher and student. There is a fiduciary relationship. And if a teacher is doing this, certainly it is extremely serious. So this was telecasted, and when this was telecasted, the police machinery and the administration machinery swing, and she was arrested. Mob has attacked her. Her property was damaged. Uma Khurana was suspended from her job, and finally she was dismissed. Later on it was found that the girl student who was shown to be thrown in the prostitution was not indeed a girl student. She was indeed a journalist. She played the role of girl and tried to implicate Uma Khurana. Why she tried to implicate Uma Khurana? Because other journalists of the channel and other people, other people, they had some property dispute with Uma Khurana, and they wanted to settle a score with Uma Khurana, and therefore this was all choreographed, all manufactured, and therefore this sting operation has brought bad name to right to press and freedom of speech and expression. It is good to see that she got the job, but we all know that not all people are aware like me and you. I often discuss sometime with my students. They often say, "Oh sir, वो एक टीचर थी, वो लड़की को ऐसे करके उसने prostitution में ढकेल दिया था." I told it is a wrong news. Damage has already been done. So Uma Khurana, ultimately I told you that there can be a defamation case also, and there can be a tort case also. She filed both the cases. but ultimately she took back the cases. You can understand Uma Khurana was a simple lady like me and you, and the channel was running in hundreds of crores. So we understand what transpired there. So legal framework, I had discussed that defamation, section 499 is there. So there should be some publication. It should be intentional with knowledge or reason to believe. And then some harm is caused in the eye of others, then it is defamatory. So in case a sting operation has ulterior motive, it has different type of intention, not to serve the public purpose, then it will be defamatory, and then the case can be registered. Of course, defamation is a offense where the complaint case has to be filed, FIR cannot be registered. There are explanations and exceptions, they also become significant. So the law enforcement officials should be careful about the sting operation. They should be very well aware of what is defamation. Then other laws, other provisions that come in picture is abatement, because we abet people to do something unlawful. So there is an angle of conspiracy also, we conspire with other persons. Impersonation takes place because we show ourselves which we are not. Then we create false evidences. And then comes the question which I want to discuss. Probably in the last I will discuss what will happen to those confessions where police officer, which has been done before police officers, but the other party was not aware of. But I will come to that later on. I will just quote one or two judgment of the Supreme Court. One is 1958 Supreme Court judgment, which clearly says that there is no universal or inflexible rule that evidence of the witnesses of the raiding party must be discarded unless independent corroboration is available. So this is good for maybe prosecution and the police officers, that even if there is no independent witness, if the witnesses available either in the form of in the raiding party or in the sting operation, if they are reliable, conviction can take place, and this case can be cited. This is a 5-judge bench, so this is a great authority. Now there are many cases which has come after that also. There are regulatory laws like Cable Television Network Regulation Act 1995, then Cable Television Network Rules 1994, and then Program Code and Advertising Code of 1994. They are very broad. They direct under what circumstances a sting operation can be telecasted, can be released on public domain. Then there are 2009 case of PUCL and Anirudh Bahal, and some tape recording was done, and PUCL case, it was held that yes, it can be done, but it cannot be done at the small level. Only Union Home Ministry or equivalent person, Union Home Secretary or equivalent person in the state, or someone to whom the power has been delegated, will give permission. This recording of phones cannot be done at the level of maybe police station. Permission is required. Of course, the good news is that the permission is granted retrospectively. In Anirudh Bahal case in 2009, it was observed that a citizen has right to do sting operation. So we have another authority which says that sting operation is a right. One can do sting operation. Then in Uma Khurana case, certain guidelines were issued, and the guidelines are very broad, and these are the guidelines for news channels, that they will obtain some certificate before telecasting, and telecasting, the certificate will be obtained from the person who has recorded, that he knows it is genuine, and it is not edited, and if edited, both the versions should be submitted. So there are certain guidelines which I am skipping. Chief editor in all cases will be responsible. He cannot say that the person was a very trustworthy person, and I have taken that. No chief editor will be responsible for that. Now, in the legal regime, so far as non-state actors are concerned, I will try to maybe sum up in maybe next 7 minutes. Non-state actors. So, a crime suppose a person commits crime, maybe trespass, it is not extinguished just because it is in public interest. Suppose someone is dealing with reputation, so section 499 comes in picture. Just because there is a public interest does not mean the crime is extinguished. So this first point goes against someone who is committing sting operations. So it should be very careful. It applies to non-state actors. It applies to state actors also. And arguments were raised in court that it was in public interest, and therefore, if some mistakes have been committed, they should be overlooked. But the court said that no, we cannot. Then criminal intent of sting operation have to be established before the liability of the person charged with commission of crime can be adjudged. What was the intention of the person who was doing sting operation? This has to be established. If he has the bona fide, if his purpose was excellent, right from the beginning, he had no oblique motive, then only the criminal case cannot be prosecuted. But it needs to be established. Then doctrine of mens rea, whether when he has committed sting operation, did sting operation in order to give benefit to someone, unlawful benefit to someone? So it can be gathered through circumstances. And in these cases, section 107 of IPC, 120A of IPC can be used. Now let me come to this sting operation case of 2003 Rajat Prasad. 2014 case of Rajat Prasad. In this case, an sting operation was done. A sting operation was done in 2003, and a minister was caught taking rupees 9 lakh. And indeed, he accepted it. And this sting operation went for 3-4 days, more than 3-4 days, in a hotel in Delhi. So certainly Prevention of Corruption Act charges were raised against the minister, but then against the sting operators also, those who have done sting operations, certain cases under Prevention of Corruption Act, conspiracy, that was also registered. Why was it registered? It was registered because with the passage of time during investigation, it was found that there are chances that sting operation have not been done with plain motive of serving public interest. There were certain facts. The facts were that the sting operation was telecasted on the news channel one day before election of a state, that is Chhattisgarh. While the sting operation was done maybe 10 days before, the court has asked, why did you take this much of time? 10 days. Why did you wait for the election? Did you want to did you wanted to give political benefit to one party and wanted to discredit the other party? Second point, it was found that the conspirators had close link with that time Chief Minister of Chhattisgarh. The sting operation was conducted against Union Minister. He also belonged to Chhattisgarh. So the case was registered against those who have done this sting operation. They came to the court, and in the court they argued that our purpose was very pious. We wanted to expose corruption. But the Supreme Court said that there are some prima facie evidences that indicate that your purpose may be pious, but then there are something which need to be investigated. So they refused to quash the proceeding. So I've already dealt with these things before elections, why this was telecasted, what is the role of those two political parties, why 12 days before, whether this trap was because of unlawful favor. So charges were indeed upheld in this case. Now, in sting operation, the another significant point is that when a sting operation regarding bribe giving is being done, then one should be very careful that the evidence of demand of bribe should also be taken care of. Suppose a person is caught red-handed and maybe it is recorded very well, but there is no proof of demand. There are Supreme Court cases which says that primary or direct evidence is required for demand of a bribe under Prevention of Corruption Act. Fortunately, 2-3 days back, in the case of in one case which is decided by a bench of 5 judges, Neeraj Datta versus Delhi, 3 days back, the Supreme Court has decided that no, for the purpose of demand, direct evidence is not required, circumstantial evidence will be sufficient. But then it is not maybe a type of case where we can say that okay, only circumstantial evidence will be sufficient. They have said that in the cases where the informer is either hostile or he is he's dead, in those cases demand of bribe as a circumstantial evidences of demand of bribe will be sufficient. So the investigating officers and the prosecutors should be very careful. I often read the news, इस आदमी को रंगे हाथ पकड़ लिया, उस आदमी को रंगे हाथ पकड़ लिया. But I think in most of the cases, at least 50% of the cases, it will not lead to conviction because the evidence of demand has to be there. So the prosecuting officers and the investigators should also take care of that. They should find the evidences of demand, and in this scientific age, it is not very difficult to find it. R.K. Anand case is probably the most significant case. In this case, a sting operation was conducted and it was found that the advocates of both the parties, that is the state advocate, that is the advocate from prosecution, as well as advocate of other party, both were trying to derail the case, and R.K. Anand indeed met the witness he should not have met. He has offered, he has suggested him to take some money and speak lie. So this, when this sting operation was telecasted, it was challenged, but the court held that NDTV has rendered valuable service to the important public cause to protect and salvage the purity of the course of justice. That way, this probably is the first significant decision on sting operation directly, where the probative force or the evidentiary value of the sting operation has been accepted, even if the other party knows nothing about the sting operation. I'm skipping other part of the discussion because I think there are certain questions so that we can discuss those questions. So to conclude, I would say that sting operations are lawful, of course, to a limited extent. They get their validity from the Constitution and judicial decisions. And sting operations, if it is done in a manner which has been referred previously as a legitimate and illegitimate way, there are two types of ways, unlawful and lawful. So the sting operation, one should be very careful that the 3 4 elements which has been mentioned, that the person should be predisposed, and the police officers or the enforcement officers can provide some opportunity but cannot persuade the person, push the person to that extent that he that goes to, means manufacturing type of crime, manufacturing crime. So this, the police officers, investigating officers, and other officers should always take note of. Thank you very much. Thank you, team National Law University Bhopal. Thanks to the officers from government department, and thank you for your patient listening. I will see the chat box, and if there are other questions, then I shall be happy to discuss those questions. Thank
Sir,
you.
questions are there in the
Sir,
Q&A
questions
section.
are there in the Q&A section.
Yeah. So should I
Yes,
address
sir,
one by
please.
one?
Yes, sir, please.
Okay. So Pankaj ji has asked that Tina factor legitimized by judiciary. See, the Tina word has not been used by judiciary, but they have mentioned, as I have mentioned, that they are aware, very well aware, that there are in certain cases where there is no other alternative for prosecuting machineries, investigation department. So therefore, sting operations are maybe legitimized. It is not. It is a permissible means to a limited extent. I find well. mm, yes. So Aishwarya has asked that if a clerk is induced to take a bribe and he does agree, but the clerk has an excellent track record of being honest, is the sting legitimate? 100% legitimate. He is induced to take bribe and he does agree. That is the significant point. And the recent judgment, 3 days back, 2 days back, I would say, Neeraj Datta case, the Supreme Court has mentioned this very clearly, that in the Prevention of Corruption Act, 2 types of words are used. One is acceptance, other is obtained. So for the purpose of acceptance, he need not to demand clearly. What he is required to do is to accept only. So even if his track record is very good, but he has accepted it and there are proof for it, then this sting operation is permissible. Of course, in a defense he can take that his track record is good. If he is convicted, probably his good track record can be taken care of in punishment. But if he has done it, even if he has a good track record, he can be, that sting operation can be permitted, has to be permitted in the law, and he can be convicted. Of course, we should be very careful that the honest persons are not victimized, because the honest persons are the soft target for many people. So Manas Sarkar, his question is, if a cyber attack is done by a security expert, may or may not be a government official, okay, to gain access to a well-known criminal person's digital device to collect evidence of some crime, will it be considered as a sting operation or a cyber crime? It is cyber crime. Means number one, it is completely unlawful, and so it is also it is made criminal under IT Act, and indeed, if the attack is on government officials, serious officials, critical infrastructure, it may amount to cyber terrorism also under section 66F in rare cases. So so I understand that your point is that he gains access to a well-known criminal person's digital device to collect evidence of some crime. I think it is still is a cyber crime. Of course, he can maybe the prosecution can uh, think of giving him some type of weightage, some type of amnesty, because he has helped the person. But this type of help can be done only by maybe government officials. So he cannot take law in hand. There is one question, one answer by maybe I want to answer one by one, but I don't know why most recent. Okay, okay. So I will take the questions. Okay. Uh, Sumat B is telling that it is not hit by 25 Evidence Act as just provided an opportunity not disposed or to commit a crime. Well, there is no clear case on this,
I think, sir,
but
the one
majority of
slide that you had left for discussion is question relating to that section.
yes. That is why I am trying
Sir.
to address it. Section 25. Section 25 says of the Evidence Act, we all know that any confession made before police officer cannot be admitted as evidence, subject to Section 27 if there is a disclosure. So there is no direct word on that. I have tried to do the research, whatever research was possible, I have done. I have also contacted a few experts in a couple of universities. 90% of the opinion say that it is hit by 25. And the idea that is given, the reason that is given by them is that the status of police officer is significant. Other party knows or don't know, that hardly matters. So if other party does not know, but whether you were police officer or not, what was your status? If you were police officer, then the law is very clear that the confession are made before you. If you ask for my opinion, I have a different opinion. I will go by maybe purposive interpretation. What is the purpose of this provision? Purpose of this provision is that the accused is not victimized, the accused is not suppressed, accused is not oppressed, accused is not threatened, and police has the power and they can do it. Directly or indirectly they can do it. But in these cases, which are on maybe videographed, where are evidences, other party is not at all aware of. So why do we have already disbelieved police through Section 25, and there is no need to extend this protection to the accused persons in those cases where there are evidence on record. So I will go with the purposive interpretation that no such type of evidences should not be hit by that. Let me take other questions also one by one. If someone commit illegal sting operation, then under which section he will be booked? Good question, very good question. See, there is no law for that. First, we need to understand what is this illegal sting operation. So, when there is a fundamental right to do sting operation and there is a court verdict that citizens have right to do sting operation. See, in what happened in Bahal case, Bahal has had the information that there is some transaction going on under Prevention of Corruption Act that is punishable. So he has made a sting operation. The state has argued, prosecution has argued that Bahal should have informed the police authorities instead of doing his own sting operation. Supreme Court said that no, why should he inform? It is your duty to know. If he had the information, he has done sting operation, every citizen has fundamental right to do sting operation. Now, so what is the meaning of illegal that we need to understand? How can be it illegal? So, a person has gone inside the house of a person, has installed certain cameras, that becomes illegal. Certainly that becomes illegal. It is violative of Information Technology Act also. So sting operation is there. He can be booked under Information Technology Act. He can be booked under IPC for criminal trespass, house trespass. If those cameras have taken some private moment, he can be booked under, again, right to privacy under criminal provision. If there are children involved in that, because in a house there can be children, then POXO can also come in picture. Then it can be defamatory also. The whole point is that if that recording has found some incriminating document, can that be presented? I think that can be presented. That can be presented. Then I will take, yes, please. Now, sir, Ghanshyam Singh ji, sir, what about recent sting operation of one of the minister of some party? Let us avoid using the name of parties. Okay? So some party who is in jail. So see, this I don't think is a sting operation. Probably this is a video which is there in the jail premise, and that video has come out. Maybe if there is some rule which says that the video cannot come out without legal authority, then those who are stakeholders, some action, some administrative action can be taken against them. This is still doubtful what was there in sting operation, what was unlawful in that. So if you want to add something, I will be able to address in a supplementary. But this sting operation is not a type of sting operation so far as I know. Are private sting operation lawful? 100% lawful. And I told you, Vijayji, that the authority for it is Bahal case of the High Court, as well as the Supreme Court cases also. They indirectly, at least, they say that sting operations are permissible. R.K. Anand case was a private sting operation, and it is not only been permitted, but the courts have indeed appreciated their approach, that we appreciate their valuable services. So private sting operations are permissible, but we should always take care of that there are privacy angle. So without permission means in some places it is already written that it is a private space, no recording, then you are violating the rules. Administrative rules are there in certain places that you are violating. You can be subject matter to that. So I think it is permissible, provided it is not defamatory, provided other rules have not been violated. Then there is a question. Dalsa Sepahi Jala. Okay. Sir, can the chamber of a lawyer or a judge be considered as a private place? Yes, it is private place for him. If it is locked, it is indeed not a public place. The chamber of a lawyer is my home like me. I'm not talking about judge. Chamber of lawyer is like my home. I can allow. It is not a public place. Anyone cannot go. In a place of a judge, maybe if it is a court, it is a public place. Then again, the chamber of a judge is not a public place. It is a private place, and he can allow people or he may not allow. So it is a private space. And is it at par with one's private room? I have already given you that yes, it is at par with. The only difference is that in my drawing room, many people come. Does it mean that I lose the right to keep it as a private room? It is private room, 100%. If not, there is no question of if not. If you have something, please give me some authority for that. How could that lawyer be left? So it is not there because it is consensual relationship, and that is not offense, and it should not also be an offense. There are two parties, they are adult, and there can be a case of maybe if some of them are married and they are married, there can be a case under maybe divorce case can be there, but it is between the parties to decide. So there is no need of punishment, there is no law to punish, and there need not to be any law. So I would say like this. Then Kumar Vikram Singh ji, his question is, that if there is no independent witness sitting officer, what is the value of evidence of sitting party members? Yes, it is. Now there are two things that we should keep in mind. One is that is the sting operation done by police or someone who has the power of police? If it is, then probably there is a weak case, because if there is a confessional statement, then it may not be accepted by the court. But if this sting operation is done by other officials who have no power of police, then this sting operation has the legal validity. Value of it is an evidence, and then R.K. Anand case is one such case, which is an authority on that. So we need not to worry that sting operation is whether it's the private sting operation, this sting operation has legal value or not. There are 2 points that sting operations, that evidence will have to be corroborated. But you remember that even if it is not corroborated, then in exceptional cases it can be means just because it is not corroborated does not mean it can be discarded. That is the verdict of 5 judges bench of 1958. Then the question of Vijay is on desirability. Do we need sting operation? 100%. 100% we need sting operation in order to expose various misdeeds that is going on. So I go with this, and sting operations have paid well in many cases. So sir will answer certain question after once I am open. Then sting operation done without credible information as to the general integrity of person, whether the sting operation is still valid. See, the integrity of the person does not matter too much. The only thing is that his bona fides are clear or not. Whether he is reaping some benefit, some financial, some political benefit. So even if he is a bad person, so he has done some sting operation, but an sting operation has bona fide, then that is valid, that is still valid. So person is certainly, if the person is means he will have to give his bona fide, establish his bona fide. I am addressing other questions also, but I will request Rao sir also, because he also wants to address it. So should I address other question also, because time is going on? But I am open to answer all questions, sir. Atul sir, what do you think?
We can choose the questions which is more appropriate, and you have the liberty to select the questions.
Okay. ठीक है. Now, if senior officer with vindicative approach, malafide intention, makes a sting operation, records something in office room to punish you, is it still legitimate, sir? See, if you think that there is malafide, and if you can establish malafide, the administrative action can be taken. The malafide has to be established, but it is very difficult to establish malafide. Then sting operation is done, and means if laws are not violated, I think they are valid. The malafide has to be proved. Then out 6 months ago be used to register an offense 6 months later. Yes, it can be. What is the problem in that? Crime never dies, even after 6 months also. Of course, the intention of the complainant will come in picture, the way it came in Rajat Prasad case. Discovery and recovery, I think it is more jurisprudential question. I will not take up this matter. Then sting operation, illegal sting operation is cognizable or non-cognizable. There is no offense as such. So cognizability, non-cognizability depends on the section which is applicable. Trespass is non-cognizable and bailable. This defamation is non-cognizable, bailable. But impersonation, if you are doing it. So sting operation videos can be produced evidence in the court of law, and whether it is admissible. Yes, it is admissible. We have dealt with this. Now the question on section 25 is said to be not legally relevant. Okay, you can go with that. It is my opinion. Then People Union PUCL conditions issued wiretapping, comment on sting or intercepted calls. I have already dealt with. that if you want to record, means if police wants to or an authority wants to record a call, there has to be a permission. They cannot do it themselves. Even nobody can do it. Indeed, means nobody can do it. Means if a phone is coming to me, I can record the call. There is no difficulty in that. I can record because it is my phone. I am doing it my property. But you cannot use a means without using your phone, you want to record the phone of other person. This is not permissible. Only government can do it, and that too with the permission of highest authority. So I can record. There is no doubt. Uh, Individual records of incoming and outgoing calls. Can it be used as an evidence if nothing incriminating related to sting is found after the search? Yes, it can still be used, but why will you use it? I do not understand. If there is nothing incriminating, it can be used if you want to corroborate. It can be used. Ultimately, it is relevant. Ultimately, this the court will decide whether it is admissible or not admissible. So I think the time is okay, and Mr. Rao sir, I will request you to also address some of the questions. It will be really great to hear you because thank you.
Yeah, thank you, sir. You addressed all the questions, and Pandey sir is also there. Pandey sir, you want to add any input further to?
Yeah, I think so. It has been covered holistically. There are few points which I would like to make in case of evidences which are being recorded by the use of technology. One example could be of drone technology. So somebody is flying drone camera and collecting some evidence, and evidence about unrelated parties have also been collected, or it may be said that unrelated parties have also been videographed. Whether such evidence could be presented before the court of law, and if it is presented before the court of law, it becomes a part of the public record. Will it not have bearing on the right to privacy of the others? So in those cases, the help of technology is being taken, and that part where that part of the video is being made blurred so that it should not infringe the right to privacy of unrelated party, but it must be done in such a way so that it must not